Good day to you and welcome to another Paddocks Club tutorial. Today we're going to deal with the topic options when trustees will not take action in response to a complaint. And I do this one on the back of Wendy McDonald's query in the discussion forum. She says that her elderly parents and gran live in a sectional title unit but are plagued by a barking dog next door. They've registered several complaints to the managing agent and trustees and about this incessant barking. In the rules of the scheme, it states that dogs must not be a nuisance, and the trustees can at their discretion ask for a dog to be removed. Wendy's parents have asked that the dog be removed, but they are refusing, saying one of the trustees that lives 8 doors down does not hear the dog. Wendy's parents get kept awake at night, and her gran presumably, and when they have visitors they can hardly hear themselves speak because of the noise this dog makes. Surely, she asks, my parents' right to live in peace and quiet are not being taken into account. She says this has become such a problem that they've put their name down at a retirement village, so clearly this scheme is not a retirement scheme. Surely there must be something that can be done. Well, let's look at some background considerations. Firstly, the very element of nuisance is always a value judgment. How much barking must there be? How often must it occur to be actually a nuisance? Very difficult to draw a line, particularly if you're emotionally affected. You're the dog owner, you're an immediate owner, and perhaps elderly people are slightly more affected by dog barking at lower volumes. Everything has to be taken into account. You don't have a right to perfect quiet in a high-density residential sectional title scheme, but you do have a right not to be unreasonably disturbed by your neighbours. So the job of the trustees is to weigh the interests of the parties and take action that supports the rules, and including the provision in the Act and the rules that people must not unreasonably disturb one another in their use and enjoyment of the common property and their exclusive use areas. For the purposes of this discussion, we assume that Wendy's parents aren't unduly sensitive, that the noise is a nuisance. Other nearer occupiers must also be experiencing that dogs barking as a nuisance, and the trustees are being unreasonable in not accepting that the experience of the trustee who lives 8 doors down is not a good indicator of her parents' and her gran's experience. So what are the options? Well, I'm sure that you'll have some that I haven't thought of, but I've just categorized a few. The first is self-help, looking at a various range of self-help options. You can get more evidence. You can persist with the complaints. You can talk to the dog owner and get others to do the same. A friendly approach might in fact produce some results, and one must at least show that one's tried that. There are also devices you can get that attach to dogs' heads and amplify the noise of their barking, which apparently reduces their enthusiasm to bark, especially for prolonged periods. You can get support from other occupiers, you can attend trustee meetings, you can even consider standing for office as a trustee. And you can go to the police. Now, the police don't normally want to get involved in internal matters, but if it's serious, I have known of instances where they'll come and talk to the person and say, look, this thing is edging on a civil wrong, so here's what we suggest. The police have quite a lot of experience in this type of thing. If you look at the Act, there is a provision for the application to the High Court for the appointment of a curator ad litem, somebody to stand in the place and act for the purposes of a court case or a court action for the body corporate. I've looked at that and I don't think that it's particularly applicable. An owner can force the body corporate to perform its duties if the failure to do so is causing an owner to suffer damages, but it's not clear to me that this type of damage is what Wendy's parents are suffering. It seems to me more that the legislature had financial loss in mind. But going to the High Court in any event, and here it's a cumbersome process, so it's expensive, you need a lot of expensive people involved, and the process of first getting a curator appointed, having the curator do an investigation, then having the curator present the investigation to the court, and then only getting instructions to act. It's long and it's drawn out, and I don't really think it would be appropriate. You could, of course, go to court directly for an interdict ordering the dog owner to stop the nuisance. At that stage, you'd need all the evidence and be absolutely clear that this is an urgent matter, and it doesn't matter how you do it, the thing is going to be costly and it's going to involve considerable delay. Wendy raises the possibility that her parents and gran might move to a retirement home that does not allow pets. Well, I suppose any Any other scheme that didn't allow pets might be better, but of course pets aren't the only thing that can cause a nuisance, so one does have to look at that. But a change, I mean, this involves costs, it involves delay. So the short answer is there are no ideal answers, but I hope, Wendy, that gives you some idea of those things that I think are options, and if we have any further queries, we can discuss them in the discussion forum. Thank you very much.